case where people will circumvent the court system and come here to process their convictions. So I am struggling with that.
Commissioner Rain.
In my mind, the way I come up with it is we must, and that's perhaps from I have some family in the legal profession, I always hear, you must judge a case on the merits of the case. You almost can't think about tomorrow. You must judge a case on the merits of the case. What that brings tomorrow is what that brings tomorrow. What is this particular case? As I said, in this specific case, is this proper? Another case that's 1/1,000,000th of a percent different, likely not proper. And that's why I'd throw on it. You've got to judge it on the merits of this particular individual case, considering all the evidence, and no other case will be similar. And I was on the fence of if there was 10, and I don't remember the exact number, I think I was with the 10 on all the other. This would be an exception due to all the reasons previously mentioned. Thank you.
Commissioner McNinch.
Yeah, and I agree with that, and that's why I'm struggling, because I think if we asked our DAG right now, she would probably tell us that to be consistently wrong is better than being inconsistent. It's more defensible, even if we're being being consistently wrong. And we've been told that in my business many times. The inconsistency is what really nails you. It's arbitrary and capricious, and that's where that's why. So I understand that balancing act, and it's kind of a little bit on one side or a little bit on the other.
Commissioner Morey.
Well, thank you, Mr. Chairman. I think Commissioner Drew made a good point for my view of this, how to approach this. Can we allow revocation of a fishing license and not a hunting license?
That's what I'd like to have, only.
Commissioner, Rob, can you come up and?
For the record, Chief Game Warden Rob Bonamici. I believe the answer to that is no, because if you go to NRS 501.1816, under number 2, if a person accumulates 12 or more demerit points before completing a course of instruction pursuant to subsection 1, the department shall suspend or revoke any license, permits, or privileges. Any, to me, indicates all of them. Any that they have or could have.
Any other discussion? Seeing none, I'll call for the motion. All those in favor signify by saying aye.
Aye.
All those opposed signify.
Nay.
No. Nay. Did you? Can we get a raise of hands on the ayes and the nays? Aye. Nay. Okay, there we are. That concludes that agenda item.
No. We're back to square one.
What's that?
We're back to square one.
We're back to square one.
Conclusions of law.
Okay. All right. Somebody go and help me out with that one. Yeah, Jeremy's writing. Jeremy's shaking it off.
It's tough being chairman.
We take it in two pieces, Mr. Chairman. Findings of facts first, conclusions of law later. Perhaps that would be simpler.
Okay.
that purpose, could I, if I restated the findings of fact I found earlier, and conclusions of law later, which will be findings of fact the department acted correctly in prosecuting this case. The plaintiff pleaded nolo contendere to the case. The judge reversed all of the fines, suspended all of the fines, suspended all of the fines. Hold on. Let me make that clear so that we're happy about it. For 2 years, so long as the defendant receives no other wildlife violation. Thank you. Plaintiff did not have any knowledge of the 12 demerit points or the implications of 12 demerit points, or knowledge of the implications of 12 demerit points at the time that he pled nolo contendere. If there's anything else, I'd probably be open to additions.
I'll second that for purpose of discussion.
Okay, we have a motion and a second. Any further discussion? Seeing none?
Okay. Findings of fact. The department, meaning Nevada Department of Wildlife, acted correctly in prosecuting this case. The plaintiff pleaded nolo contendere to the charges in this case. The judge read right from the statement. Suspended all of the fines for 2 years so long as the defendant receives no other wildlife violation. The plaintiff did not have any knowledge of the 12 demerit points or the implications of 12 demerit points at the time of his pleading.
So we have a motion and a second. Any further discussion? Commissioner McBeth.
I'm going way out on a limb here. Is there any way that we can, and we'd obviously have to suspend this proceeding, and have Mr. Hunter go back to the Justice Court in Eureka to get clarification and amended judgment and sentence of what the judge meant by the judgment and sentence that was handed down? Is that, and I know it's probably never been done before, but it's all I have left.
I totally agree with Commissioner McBeth on that. That's the one person I'd like to ask a question right now, and that's the one person we don't have to ask a question, because that could clarify a lot of things for all of us. So with that, we still have a motion on the floor that we need to deal with.
And throw out, I'm trying to figure out what we're doing. So we're talking, we could suspend it and try to get a hold of the judge on the phone? You're talking about have him doing it?
No, I don't think that's feasible. What I meant is to actually put the onus on Mr. Hunter to go back to the court, and he'd probably have to get an attorney, because they'd probably have to file a motion to seek an amended a modification of the judgment and sentence. And I'm not a criminal attorney. I'm just kind of applying general procedural type stuff that I've seen happen in civil type stuff that I do, if there's a hanging question on this sentence that was issued by this court, and it leads me to wonder what the court really meant as far as the suspension of the fines and fees, and was he making a statement as to leniency as to this defendant, and are we by what we're about to do going to go against that, and was that really intended? And I just think that if we at least give him the opportunity, and then we come back in December, we reconvene this, and based on whatever answer he comes up with, we'll make our decision.
Yeah, my biggest question is the way that it was suspended with no more further wildlife violations the next 2 years. So it made it sound like the judge anticipated he was going to participate in wildlife activities in the next 2 years.
So
Commissioner Drew?
we do have a motion on the floor, and I don't think I have an issue with the findings of fact. But would the proper way to do that be in the ruling portion, the subsequent motion that's coming up? Once we establish the finding of facts.
Chairman Robb, if I could make a suggestion. If the commission decides to, I guess, table this until the December meeting, it would give me an opportunity. I do believe there is some way that we can work out an agreement with Mr. Hunter if he just wants his fishing privileges. I'll need time to do additional research, but I believe there may be some way, and then that way he can explore Commissioner McBeth's suggestion with the criminal court as well. So if you do decide to go that route, we won't need to do a findings of fact today. We'll just continue it until December, and we can have the parties come back.
I'll withdraw the motion, and I will make one point about that, the portion about the suspended for 2 years pending any other violation, is that is, in my limited experience, that is universal with suspending fines. In my limited experience, suspend the fines, but if you come back in the next couple of years, the time frame sometimes changes, but we're not talking wildlife stuff, anything. But if you come back before my court, those will be reinstated. That has been universal in my limited experience, and I understand it happens in many other courts as well.
Commissioner McBeth?
Okay, I just want to point out that, not having wildlife violations doesn't necessarily mean that the court meant that, that he, or insinuated that he had license privileges, because he had wildlife violations without having a license. In other words, he could go out and poach a deer without having a tag or a license and still have a wildlife violation. So, but we don't know. We don't know what the court, and that's my point. That's my point is, if the judge truly wanted to let the civil sanctions play out in full, then he can come back and tell us that he had no intent to impact the civil side, the demerit points, and that's the end of it. But if he truly did, then he can make a statement, or in lieu of that, the department can get this worked out.
Commissioner Wallace?
Thank you, Mr. Chairman. Just for procedural, I withdraw my second on that as well. And I just want to throw it out there as well that in my experience with these appeals, to my recollection, none of them have had suspended fines. Everything that has come before us, there were no suspension of the fines. Just throwing that out there.
Chief Bonamici?
For the record, Chief Game Warden Rob Bonamici, excuse me, if I might add, we have done exactly what Commissioner McBeth has suggested in the past with other cases, where I receive a phone call from an individual after sending them a letter, and they say, no, that was not the judge's intent. The judge clearly intended for me to retain my privileges, whether they be guiding or what have you. And I said, that's fine if you can get a letter from the judge stating that. And when they have produced those, we haven't even brought those cases before you.
That is correct. So I'm aware of one of those. So if that happened, we wouldn't even have to have it on the agenda the next time.
So, Mr. Hunter and your representative, do you understand everything that we have been saying here and what it is you need to do
We do, sir. However, I guess the ray of hope to try to keep someone on a small pension from having to get an attorney to open up a recorded judgment. If there would be some way, as you have said, that he could work with you to suspend his hunting license and regain his fishing license, at least in the year 2013, that would be better than going through the expense of getting an attorney and driving all the way up to Eureka.
And just in response to that is that Chief Bonamici just mentioned that others have gotten letters from the judge, and so, maybe you could explore that.
I will explore that.
And if the department is willing to accept that as the intent of the judges, then then I think it all gets resolved and you don't have to do the hearing thing. So anyway, correct me if I'm wrong, if that's, am I correct, Rob? Okay.
The only other thing I'd like to point out is if somewhere along this process, if the department would have offered Mr. Hunter an administrative hearing, which did not happen before the sanctions were imposed, well, then we could have discussed a lower plea and perhaps not even come close to giving you a precedent you don't want in your room. We understand that. But I'd just like you to consider that there was never an opportunity for him to do that in this process. So processes were solved or followed, but I don't believe justice was. Thank you.
Commissioner McNinch.
All right, and I'm just gonna say, I think the door's been kicked wide open for you. It's kind of like arguing past yes, if you pick up what I'm trying to say.
I thank you very, 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 very much. All I want is just to fish. I haven't hunted in quite a while. I was just a passenger. That's all I can say. I don't think I'm guilty.
Okay.
Thank you very much, sir.
Commissioner Macbeth.
All of you.
Okay, I'd like to make a motion to, on agenda item number 8, license appeal hearing, Mr. Jack B. Hunter, that we suspend, this, is it the correct word, hearing? That we table or suspend? Continue this proceeding with regard to the revocation of his hunting and fishing license privileges until the December meeting, to allow him to get additional information from the Justice Court in Eureka County as to the intent of their judgment and sentence, and to also allow him to work with the department with regard to any matters that they may be able to work out and settle, and that in the event that we get a letter, that the department gets a letter from the court or otherwise works this out, that this matter will not have to be brought back onto the December meeting, but other than that, it will come back on December.
Second.
Any more discussion?
If I could offer just a lesson, the judgment of the chair of this commission, that it is not warranted to bring it back. That way it leaves, because he's going to be talking with the department. But there might be reasons we can't foresee. We should put it on it will continue it unless it is not warranted to be on the December agenda. At the, simply leave it up to the chair. That makes it less rigid and gives the chair the authority to do that. Just an option?
The only way that this hearing will not be on the agenda in December is if Mr. Hunter withdraws his request for a hearing.
Okay. That's
okay. Cancel that then.
And so if he gets a letter or if we are able to figure out some way to, what we'll do is we'll bring it for informational if he does request that the hearing be withdrawn. So we'll talk with the chairman, see if he wants it back on the calendar. But if Mr. Hunter withdraws his request for a hearing, it won't be on the December agenda.
All right, thank you. So we have a motion and a second. Any more discussion? I'll call for the vote. All in favor say aye.
Aye.
Opposed? Unanimous. It's 20 after 12. Oh, Chief Bonamici.
I'm sorry to interrupt, but if I may, just for clarification for Mr. Hunter, he can go ahead and fish and hunt and trap because this motion is stayed, or his privileges are stayed until such time a commission makes a determination.
Okay.
And that's in NRS 501-1816 as well.
All right, thank you.
4A.
Thank you. It's 20 minutes after 12 when I said that we were going to take lunches. And we're going to start this at 1 o'clock sharp. If we've got a quorum, we're going, so don't be late. We're in recess.